Bienvenue à la 134e.
Welcome to the 34th meeting of the Standing Committee on the Status of Women for the House of Commons.
Points. Please wait until I recognize you by name prior to speaking, and all comments should be addressed through that of the chair. Please raise your hand if you would wish to speak, and I will certainly track time accordingly and will provide a time signal when there is 1 minute left, and again when there is 30 seconds left. Thank you in advance for all of your cooperation. Pursuant to Standing Order 1082 and the motion adopted by the committee on Wednesday, September 25th, 2024, the committee will continue with its study of gender-based violence and femicides against women, girls, and gender-diverse people. Before we welcome our witnesses, I'd like to provide a trigger warning. We will be discussing experiences related to violence and femicides. Indeed, this may be triggering to viewers with similar experiences. If any participants feel distressed or need help, please advise the clerk at any point. For all witnesses and for all members of Parliament, again, we need to recognize that these are very difficult discussions, and it's important for all of us to be as compassionate as we can. For today's panel, from the Office of the Federal Ombudsman for Victims of Crime, Dr. Benjamin Roebuck, Federal Ombudsman for Victims of Crime. Royal Newfoundland Constabulary, Sergeant Lisa Harris, Non-Commissioned Officer, Criminal Investigation Division. And Women Abuse Working Group, Erin Griver, Co-Chair, joining us by video conference. At this point, we will begin with opening statements. Dr. Roebuck, you have the floor for up to 5 minutes.
Thank you, Merci. I appreciate the invitation. I'm grateful for how you've been holding space to listen to survivors. I think that their courage demands some action from all of us. We're on the traditional unceded territory of the Algonquin Anishinaabe people. As we gather during the 16 days of activism against gender-based violence, we're reminded of the disproportionate violence faced by Indigenous women, girls, and Two-Spirit people, a crisis rooted in colonial violence and systemic inequities. Now is the time for action, for justice, and reconciliation. As Federal Ombudsperson for Victims of Crime, our office is an existing accountability mechanism at the federal level for survivors of GBV and families of women and gender-diverse people whose lives have been ended by hate. We provide a direct service to resolve complaints about federal agencies connected to the criminal justice system. We're responsible to help policymakers respect Canada's obligations under the Canadian Victims' Bill of Rights, which is quasi-constitutional, and to understand systemic issues that negatively affect survivors. I do support LEAF's recent proposal to create a GBV commissioner in Canada. I saw many of you at the launch event, and request improved resourcing and legislation to support our mandate. This year, we launched a national systemic investigation into how survivors of sexual violence are treated in the Canadian criminal justice system. We've completed 80 interviews with survivors, consultations with more than 200 stakeholders, and we're nearing completion of 40 virtual roundtables. 2 weeks ago, we launched an online survey for survivors that already has about 400 responses. We're building a comprehensive understanding of systemic gaps and promising practices. What we've learned so far is sobering. Today, I'll focus on 3 areas where federal leadership can drive change. First, the R.V. Jordan decision. It was intended to address unreasonable delays, but created unintended consequences. In some cases, despite having adequate evidence, police or Crown will delay charges because they want everything prepared when the Jordan clock begins at the time of charge. This increases the risk for survivors and for public safety. The ruling has incentivized the allowable use of motions in court. We've seen an increase in motions contesting testimonial aids and requesting survivors' private therapy records. We've heard about sexual assault charges preceding a simple assault because it's faster with a higher prospect of conviction. And we've been hearing about serious sexual assault charges, including against women and children, being stayed. In one egregious example, awful, a survivor was sexually abused by her stepfather for 8 years while her mother condoned the behavior. Both parents were charged. Her mother was sentenced to 42 months in prison, And all charges against her stepfather, the abuser, were stayed because his case was more complicated. That's not what justice looks like. Section 278.1 of the Criminal Code was introduced to protect privacy rights of survivors of sexual assault. In 2022, the Supreme Court affirmed its constitutionality. It also affirmed that judges must consider society's interest in the reporting of sexual offenses and in survivors having access to treatment. In practice, this provision has become a tool to intimidate and undermine survivors' credibility. Across the country, we've heard that subpoenas for counseling records have increased, and that this creates allowable delays, that judges are hesitant to deny requests in case of appeal, and that survivors feel unsafe seeking mental health support when they need it most. In our survey so far, 20% of survivors said that they wanted to speak with a counselor, but felt like they couldn't because their records could be subpoenaed. 10%, I believe it's 13% now, said they didn't report to police for the same reason. That's evidence of a chilling effect. Survivors should not have to choose between healing and justice. Survivors of intimate partner violence and sexual assault continue to report that their safety is overlooked by the criminal justice system. One person in our investigation said, "I don't want to be another woman in a body bag with people wringing their hands, wondering how this happened." It's time for Canada to prioritize survivors' Section 7 charter rights to life, liberty, and security of the person. And it's time to strengthen the Canadian Victims' Bill of Rights with enforceable rights to information, participation, and protection. Thank you.
Excellent. Thank you for your testimony this afternoon. Next, I would like to welcome Sergeant Harris. You have the floor for up to 5 minutes.
Thank you. Thank you, Chair, members of the committee, and distinguished guests. I would like to express my gratitude for the opportunity to address the committee on the critical and deeply personal subject of gender-based violence, specifically intimate partner violence and femicide. My name is Sergeant Lisa Harris, and I am a member of the Royal Newfoundland Constabulary, the Provincial Police Service of Newfoundland and Labrador. I've been serving with the RNC for almost 20 years, during which time I have had the privilege of working in both urban and rural settings. I've served in operational patrol services, responding to emergency calls as a first responder, in the Internet Child Exploitation Unit, the Child Abuse Sexual Assault Unit, and the Intimate Partner Violence Unit under the Major Crime Unit of the Criminal Investigation Division. Currently, I oversee all of these investigative units as the Criminal Investigation Division Supervisor. I manage major investigations, most notably homicides. This past summer, my colleagues and I had the opportunity to speak with MP Michelle Ferreri about my experiences working in the Intimate Partner Violence Unit, and I would like to thank her personally for providing me with a platform to bring a voice to the many women who are unable to speak for themselves, and especially to those who are no longer with us. Among these women is Courtney Lake, whose story I will share with you today. Courtney Lake was a 24-year-old mother. In April of 2017, she reported being assaulted by her ex-boyfriend, Philip Smith. Smith was arrested and charged for the assault in May. He was placed on conditions to remain away from Courtney and her family. Yet on June 5, 2017, Courtney reported that Smith had breached these conditions by contacting her and showing up at her home. She also disclosed that Smith had shared intimate images of her without her consent. Philip was arrested again and charged with distributing intimate images and breaching his conditions. He was released from custody on June 7, 2017. Less than 24 hours later, Courtney's mother, Lisa, reported her daughter missing. The investigation revealed that after his release, Philip had contacted Courtney, who agreed to meet him to exchange personal belongings. Tragically, Courtney was never seen alive again. While the RNC investigated Courtney's disappearance as a homicide, Philip was located deceased. His death was ruled non-suspicious by the RCMP. He was the only suspect in Courtney's disappearance. Courtney Lake disappeared hours after her abuser was released from custody. She is believed to be a victim of homicide. The death of Courtney Lake highlights the tragic consequences that can happen when those accused of intimate partner violence are allowed to remain free on bail, with little repercussions for breaching court orders. Her story is one of many that demonstrates the urgent need for stricter bail conditions for those accused of intimate partner violence. In IPV cases where power and control imbalances overwhelmingly affect female victims, most police forces take the choice to charge an offender away from the victim. If there are reasonable and probable grounds to lay a charge, the police must act, regardless of the victim's cooperation. The use of electronic monitoring systems, such as ankle bracelets, to monitor offenders and ensure compliance of court orders would assist in police investigations, especially in relation to the compliance of court orders. They would also serve as a deterrent to offenders. Furthermore, this would remove the burden from victims who may fear retaliation or feel isolated from the justice process. In Canada, we have mandatory reporting laws for child abuse, which apply to everyone, from teachers to doctors to politicians. The Public Health Agency of Canada recognizes that children who witness family violence suffer the same emotional and psychological consequences as those who are directly abused. However, public awareness of the impact of witnessing intimate partner violence is lacking. Mandatory reporting laws for intimate partner violence and greater public education about the harm done to children who witness violence, I believe, are areas in need of urgent attention. Canada already has mandatory reporting for health professionals for certain injuries, such as gunshot and stab wounds. Strangulation is an extreme form of coercion and control. Its presence in an intimate partner relationship is also one of the strongest indicators for future intimate partner femicide. Mandatory reporting to police of non-fatal strangulation in healthcare facilities would allow law enforcement to take action to ensure the safety of the victim and possible prevention of a femicide. Coercive control is a serious and pervasive form of domestic violence that impacts the victim's safety, well-being, and mental health. It involves a repeated pattern of behavior used by an abuser to establish and maintain power over the victim, often through tactics such as intimidation, threats, manipulation, and isolation, making it extremely difficult for the victim to escape the cycle of abuse. The effects of coercive control can be long-lasting, often leading to severe psychological trauma, depression, anxiety, and in some cases, physical harm. This pattern of abusive behavior is not just an isolated incident of violence, but an ongoing and calculated effort to dominate and harm the victim. Adding coercive control to the criminal code is necessary to hold the offender accountable and protect the victim from further harm. To be clear, I believe stricter bail conditions, the implementation of mandatory reporting of intimate partner violence and strangulation, criminalizing coercive control are crucial to enhancing the protection of victims and holding abusers accountable. These measures recognize the insidious and often invisible nature of intimate partner violence, including psychological abuse and the dangerous escalation to physical abuse. Together, these measures would create a more robust legal framework that prioritizes victim safety, promotes early intervention, and ensures that perpetrators of intimate partner violence face justice, helping to break the cycle of abuse and prevent further harm. Thank you.
Thank you very much, Sergeant Harris. Ms. Greiber, you have the floor for up to 5 minutes.
Thank you. Hello, I want to thank you for your time and for the invitation to attend today. My name is Erin Greiber, and I've been working in the gender-based violence, intimate partner violence, and violence against women sector for 30 years. I'm director of Innismuch House, the first women's shelter to open in Canada. We're a 40-bed shelter for women and children. I'm also co-chair of the Women Abuse Working Group in Hamilton, which is also known as WAG. WAG is a violence against women coordinating committee consisting of organizations and individuals who are the subject matter experts committed to supporting survivors of gender-based violence, intimate partner violence, and sexual violence in the city of Hamilton. WAG is the only multi-sector table that focuses on gender-based violence and intimate partner violence in Hamilton and holds the necessary experience and expertise to propel change. And this table has been in existence for 30 years. Femicide describes the intentional killing of women, girls, and other gender-diverse individuals by men. The most common perpetrators of femicides are men, who are either the woman's current or former intimate partner, a family member, or someone known to them. Gender-based violence has been called the shadow pandemic. Few people realize how widespread the problem is because the stories rarely receive more than local attention. Indigenous, Black, and 2S LGBTQ plus women, girls, gender diverse individuals, and women with disabilities are at increased risk and experience disproportionate levels of gender-based violence. Every life lost to femicide tears a hole in the fabric of our communities. We honor their lives and commit to making change to prevent future femicides. Naming men's violence as the problem is part of the change we need to make as a society. We can't change if we can't name it. For every femicide, there are more survivors who are not safe in their homes, workplaces, and communities. We can do more to reach out and support them. We can engage their intimate partners, family members, friends, coworkers, and acquaintances to end the violence. There's no commitment to prevention in Ontario or Canada. For 20 years, domestic homicide death reviews have provided recommendations that can move us forward towards prevention. It is time to review our progress and invest in the evidence to see stronger social returns. There are successes to build on. There are experts and advocates in every community who can help. Most femicides are preventable. There are clear warning signs and indicators of escalating risk in 99% of cases. We can take the steps to reduce risk before it escalates. The Ontario Domestic Violence Death Review Committee provides strong evidence and recommendations that can guide us. We ask that you do everything in your power to protect all citizens from gender-based violence. Your influence and—
Sorry to interrupt you just for a moment. We're having the translation issue, so I'll just stop your time for a minute. So I'll continue to speak in English, and we'll see if we can get the translation back in sync. So I think it's back in sync. So I think what I'm understanding, Ms. Greiver, is that I need you to slow down a little bit.
Sure.
Yeah. So do we need to go back a little bit, or do you want to just, I'm looking at the group for advice here. Do you want her to start from the top, or do you want her just to start in the last?
Peut-être les deux dernières phrases. Là.
Okay. Perhaps
Last two sentences, please.
two.
Sure.
And then we'll restart your time. Thank you.
Okay. There is no commitment to prevention in Ontario or Canada. For 20 years, domestic homicide death reviews have provided recommendations that can move us toward prevention. It is time to review our progress and invest in the evidence to see stronger social returns. There are successes to build on. There are experts and advocates in every community who can help. Most femicides are preventable. There are clear warning signs and indicators of escalating risk in 99% of cases. We can take steps to reduce risk before it escalates. The Ontario Domestic Violence Death Review Committee provides strong evidence and recommendations that can guide us. We ask that you do everything in your power to protect all citizens from gender-based violence. Your influence and leadership can help us develop an effective community response. We need your commitment to prioritize prevention before the next murder. In Ontario, in 2024, so far, there have been 59 confirmed cases of femicide. We need you to recognize the urgent need to help us move forward towards prevention and at the same time increase funding to stabilize services for survivors and their families. Over $100 million has been invested in trying to reduce the backlog in the courts since 2021. $100 million doesn't seem to have made a dent. We continue to fund the wrong end of the problem. There is not enough money in the world to reduce the backlog when our only response is after the fact of violence. It is a simple equation. If you intervene earlier to reduce risk and prevent the escalation of violence, fewer offenders will enter the justice system. There will be a reduction in cases, costs, and femicides. To change our current state, there has to be strategic and long-term investments in prevention that spans affordable housing and poverty. For that, we need vision and collective leadership at all levels of the system. The 2019 Missing Murdered Indigenous Women and Girls final report and calls to justice provide a vision and a framework for working towards transformation. Gender-based violence and violence against women are rooted in gender inequality and the abuse of power and harmful norms. It refers to harmful acts directed at an individual based on their gender and disproportionately impacts women, girls, especially marginalized and Indigenous women, as well as two-spirit, trans, and non-binary people. It's important to look at the reality of what is happening here in Canada and within our community. In Canada, 44% of women reported experiencing intimate partner violence in their lifetime. That's from Stats Canada 2021. On any given night in Canada, 3,491 women and their 2,724 children sleep in shelters because it isn't safe at home. Approximately every 6 days, a woman in Canada is killed by her intimate partner. Indigenous women and girls are 12 times more likely to be murdered or missing than any other woman in Canada, and 16 times more likely than white women. Violence against women infiltrates every level of society, our communities, our schools, our workplaces. The City of Hamilton was the 34th municipality in Ontario to make a declaration of intimate partner violence and gender-based violence as an epidemic. Today, there are over 95 municipalities and counties that have declared gender-based violence and/or intimate partner violence an epidemic in Ontario. Hamilton has shown a deep commitment to this work, not only by making that declaration, but also by agreeing to develop recommendations with WAG that will further address gender-based violence, intimate partner, and sexual violence in Hamilton. As evidence in our WAG snapshot for 2023, outlining statistics gathered by over 20 member agencies, gender-based violence, intimate partner violence, and sexual violence are urgent matters to be addressed. In 2023, there were over 5,993 shelter crisis helpline calls, 1,735 calls to the Sexual Assault Center's crisis support line, 1,130 women and children who access shelter, and over 5,644 requests for VAW shelter beds that were turned down due to shortage of beds. And there's a 6-month wait list to receive counseling services from the Sexual Assault Center and a 6-month wait list for supervised access program services. These stats only represent those that were able to reach out for services. As we know, reporting intimate partner violence and sexual violence is vastly underreported, and for reasons including fear of police court system intervention, lack of trust of criminal justice system, and fear of shame and stigma. We can only imagine the number of people experiencing violence and needing support. Indigenous women, BIPOC women, newcomers, and refugees, immigrants, sex workers, and 2S LGBTQIA+ community are disproportionately affected. Rural women in Hamilton are also affected. Even though 43% of Hamilton is considered rural, many of Hamilton's resources are only accessible in urban areas, which creates many barriers for women experiencing violence to access key supports, which enhances their safety. Gender-based violence and intimate partner violence intersects with many other experiences, requiring Hamilton to provide further support for equity-deserving groups, including women experiencing homelessness, living in encampments, needing more robust mental health, and additional support. The knowledge and experience that is represented within the sector is critical to moving forward to address the real risks, identify priorities for prevention, and determine meaningful solution that leaves no one behind. Meaningful engagement must begin with a foundational commitment to working in collaboration with individuals and organizations that have long served women and gender diverse individuals experiencing violence within our community.
Thank you. Thank you, Ms. Greiver.
Tink you.
Perfect.
Thank you for your time.
Thank you. Okay, so thank you to all witnesses for your opening remarks. At this point, we'll start with MP Ferrari. You have 6 minutes.
Thank you so much, Chair, and thank you so much to our witnesses. Powerful, powerful testimony. Did I get it right, Ms. Harris? It's Courtney Lake? Yes. Yeah, thank you. I'm sure Courtney's family is very grateful for you sharing her story. One of the things I hear the most often is to say their name. I hear that from moms and dads who've lost children and victims of crime. So thank you for sharing Courtney's story. Mr. Ombudsman, can I call you that?
You can call me Ben.
Ben, thanks for being here. Thanks for what you do. Right now, the Victim Bill of Rights, which was created in 2015, is coming up to its 10-year anniversary. Those rights, are they enforceable? If I come to you and I'm a victim of crime and I want my rights enforced, are they enforceable right now?
They're not. We negotiate as a federal complaints mechanism, but if agencies don't want to comply with them, there's not a solid mechanism to make sure that they're followed.
Why are they not enforceable?
Because the law itself has so many disclaimers in it that there's no right to appeal, no right to standing, and too much emphasis on discretion, even though that was trying to be protected. We need to strengthen it.
Been significant ask from your office, from MPs, from victims. I have a letter here written to the Justice Minister in July, and nothing has been done to enforce these rights. Have you been given a reason or a response to that?
I think we've been asking for involvement across government to say we all have a role in responding to these things, and I think victims' rights aren't opposed to the rights of accused, and it's a nonpartisan issue. We all want to do better and support survivors.
I would challenge you a bit on that, because I think it does get partisan when the policy doesn't protect victims, and I think that's where it is partisan, because the politics are preventing the victims from having their rights enforced. There is in Bill C-75, 493.1 of that, it says, in making a decision under this part, a peace officer, justice, or judge shall give primary consideration to the release of the accused at the earliest reasonable opportunity and on the least onerous conditions that are appropriate in the circumstances. And for people who don't know, the word shall is considered mandatory language. This is in Bill C-75, which means that a judge has to give the least amount, the least onerous conditions that are appropriate. And when we look at your letter, and what you're asking, what you've said, the same time violence associated with drug trafficking and firearms causes significant harm to Canadians. Many victims of crime have supported mandatory minimum penalties, believing they provide meaningful consequences. In addition, since victims and offenders often know each other and live in the same communities, support for longer sentences relates to personal safety. So Bill C-75 is preventing victims from having the justice that they want, because to Courtney's story, Ms. Harris, they're getting released. Would you like to see a change to Bill C-75 in this particular section here?
I think the document you just read from our office makes a clear recommendation to better consider survivor safety in release decisions, that there should be a duty to consult with survivors. We can't assume what protections might be effective. We have to talk with people to understand. The CVBR does say that every victim has the right to protection, and we actually have to interpret that at an individual level, but we can't assume that it will happen. It has to be brought into the criminal code so that the CVBR has effect.
Are judges, do they have the tools to consider victims' perspective when sentencing? I see you shaking your head, Ms. Harris. Do you want to comment?
Yeah, I can give a lot of very recent examples where the victim's safety has not been considered when it came to imposing conditions on individuals upon release. Police officers are bound by that very bill, where we try to have the most lenient conditions on err in a element of restraint. We try to not impose too many unreasonable conditions on individuals. However, from my perspective in the offices that I've worked, we say for intimate partner violence in particular that we take the conditions that are going to be impose the greatest safety. We've had situations where judges have released offenders, male offenders, to reside at the address the victim resides at, and said the police will remove the victim from the residence, which we absolutely will not impose that. So, yeah, we definitely have a lot of examples where and we're lucky in Newfoundland because we have a really good working relationship with the Crown attorneys. However, the consultation's not there with the judges in particular, nor is the training really there to kind of get with 2024.
I hear that so often about the training. I only have a few seconds left, and I was going to turn it over to my colleague to get some questions in, but I just wanted to put this on the record because this was the story that you guys shared with me at the roundtable. The St. John Syrian community is grieving and expressing shock following the slaying this week of a mother of 5 children who went to police several months ago about alleged abuse at the hands of her husband. He was out on bail, correct?
He was out 42 days when he kidnapped and killed his wife, his ex-partner.
And I just saw the heartbreak in your eyes, both of you investigators, that you knew it was going to happen and you felt like your hands are tied. So this trauma, the victims aren't just the people, it's the frontline staff. And I want to take a minute to recognize that as well, that you guys are also victims because you see the train coming and the trauma and the murder, and your hands are tied because of the justice system and these policies. Thank you for what you do.
Thank you.
Thank you, MP Ferrari. MP Sidhu, you have the floor for 6 minutes.
Thank you, Madam Chair. I will share my time with Emmanuel. My questions to Mr. Robeck. Last year in Ontario, 59 sexual assault cases were stayed or withdrawn for unreasonable delay. We know there's a lack of provincial court resources driving this. Could you tell us more about the impact stays or withdrawals have on the victim in these cases?
Oh, they're devastating. And it's such an entire waste of public resources to make people go and testify on the stand and wait and appear at different hearings and then to have it all collapse at the end. It has a significant trauma impact. There are ways to reduce delays by providing better protections to survivors, which I'd really like for the committee to explore if you're able.
Thank you. You also spoken in the past about how survivor experience re-traumatization in the justice system, how they can feel disposable once their testimony is heard, right? Is there a need to train, educate court officials or on trauma and victims? What need to be done on that side?
Yeah, absolutely. I think the descriptions that we hear from survivors of being cross-examined and going through court are very much like sexual violence. In any other context, we would recognize it as sexual harassment, that people are, through power, being forced to be exposed and being told that they liked it, they wanted it to happen, and it's all condoned by the state. That's not okay, and we've heard from too many people that that process caused more harm to them than the sexual assault itself. And so we definitely need to be more attentive to trauma. There's ways that can improve the truth-seeking function of the courts by providing better protection so survivors feel like they can participate safely.
Thank you. Over to you, Madam Chair.
So thank you to all the witnesses. My question is also to Mr. Roebuck Benjamin on the Jordan decision. I know that a lot of it falls within the province's lack of resources. I think that that's like a huge reason why a lot of the cases are stayed. But I'm wondering if you can share what the federal government could do to improve this situation. What is our role and what can we do specifically that would help improve the situation?
As part of our investigation, we've been talking with Crown attorneys across the country, and I think in most provinces and territories at this point. One of the examples that was given to us was 5 days set aside for a human trafficking trial. 3 days were spent arguing whether or not the sexual activities connected to trafficking could be admissible, and 2 days were spent contesting testimonial aids. Crowns have asked us to recommend adding human trafficking to the rape shield laws in Section 276 and say that would save a lot of time and pain for survivors. And then we'd like to see testimonial aids being more presumptive. There's no need for somebody to contest what the survivor needs to participate safely. So the federal government could strengthen both of those provisions and many more in a way that strengthens the protections for survivors and actually reduces delays and saves money.
And just for my own knowledge and the knowledge of the members here, when we say an unreasonable delay, what do we mean? What types of, what kind of delays are considered unreasonable in these cases for them to be stayed?
Well, it's really tied to a timeline. And there's better people who can speak to the legalities of it, but there's Crown delay and defense delay. Regardless, if there haven't, once it's past that timeline, then there's a risk of it being stayed.
So a defense team can purposely delay it and it reaches that amount of time and then.
It can be discounted. So if it's deemed that the defense was intentionally delaying, then that comes off of the clock. But what we're seeing is that motions that are allowable, so it's something that can be described as beneficial to the case, those are increasing to also drive the clock.
If I can just add on that from a police perspective, the investigations we see today are much more complex than they were back when Jordan was first heard. So, I mean, we have several trials that are scheduled in the near future that are automatically scheduled for 5-6 week time period. So you can imagine, and these ones involve significant child sexual exploitation, potential human trafficking. You can imagine how complicated that investigation is. So to get through that 5 to 6 week period without any significant, and the defense has the right in Canada to provide, justifiable arguments against certain processes. So to say that that's part of where the delay comes from, but those Jordan timelines were set when investigations were less complex as they are today.
Is there a reason for that complexity, that change in complexity over the last?
We all have one of these in our hand, and the ability for our computer forensics units and our analysts to crack these devices, which they'll assist in investigations, are very delayed, very behind. We're always trying to play catch up.
Okay. I have less than 30 seconds left, so I'll just thank the witnesses for being here.
CA LaRouche, you have the floor for 6 minutes.
Merci beaucoup, Madame la Présidente. Merci aux 3 témoins d'être avec nous en ce début de soirée pour nous parler, malheureusement, de ces violences et de ces féminicides, alors que nous sommes en pleine journée d'action contre les violences faites envers les femmes. Est-ce que vous m'entendez, Madame Harris?
It's not translating, no.
Interpretation is online. I'll continue to work if we have the interpretation available.
You, Adrienne, it's working again.
We have, of course, specific days that are set aside for recognition of violence against women or gender-based violence. In Quebec, the Polytech, for example, on December the 6th. How can we deal with this epidemic, and we can call it an epidemic, of femicide? No, but Mr. Roebuck, first of all, you spoke of an issue that is of particular interest to us. You thought Jordan delays. On the 30th of May, my friend, Mr. Trudel, tabled a bill that those who are acting in crimes against women cannot escape justice. Have you had a look, perhaps, at this proposed draft bill here? The link between the Jordan decision or principle, and the fact that we see a lot of charges being stayed. Well, thank you for the question. I'll answer in English.
I don't think the notwithstanding clause should be required to protect survivors from these dangers and from Jordan delays. I think that we need to see more emphasis on the Section 7 charter rights of survivors to life, security of the person. That hasn't been as developed as it needs to be, and if we're talking about femicide, those rights are critical and foundational, and they should drive legal reform to line up with the rights that survivors have in Canada. So I think that can challenge Jordan.
De votre côté, Madame Harris,
From you, Madam Harris, have you heard of this particular bill? And what do you see the significance of this bill and to try to counter the ill effects of Jordan decision?
I've heard of it. I have not reviewed it quite in depthly. Certainly, from all investigative areas as a police officer, Jordan has had significant implications. I think back to my time in the Internet Child Exploitation Unit, investigating some of the most serious crimes towards our most vulnerable in society. And the delays that would be caused from laying a charge because of the fears of Jordan implications, because it was kind of new at that time. So certainly from a policing perspective, we've recently in Newfoundland had a homicide investigation that was stayed due to Jordan delays. Concern, we had a guilty verdict today for a skating coach who committed sexual crimes against young skaters. There was concerns that there would be Jordan delays there. So certainly from a policing perspective, that is a very high concern for us.
de nombreuses victimes l'ont aussi nommé ici, notamment.
Well, many witnesses appearing before us have also told us that they're following the process of this bill. Now, the administration of justice, of course, is a provincial jurisdiction, but I'd like to raise an issue which is, in fact, a federal responsibility, the appointment of judges. And how is it that there's such a delay in appointing judges to the courts? How can we get the Department of Justice to improve and accelerate the process, leaving hanging all these victims? You spoke of the Jordan principal, Mr. Roebuck and Ms. Harris. If each of you could perhaps give me a point of view on that.
Resourcing into the justice system that can turn off the flow if we're not investing in prevention. So judges certainly need to be in place, and I think there's been more recent progress to actually drive appointments. We still hear about judges that have no training in criminal matters that are listening to cases that involve complex power dynamics and gender imbalance. So there needs to be more work on that structure.
Certainly, and I know in Newfoundland in particular, we don't often see a delay, but then, there's a lack of accountability measures for the judges who are appointed to the bench and still, do not have the understanding of the victims' rights or the nuances that have now, as a society, we're much more aware of gender-based violence and the trauma when it comes to a victim providing testimony. Strangulation in particular, if you look at the research, it talks about if there's a progression in strangulation after a repeated number of occurrences, the actual cognitive ability of a person changes significantly and declines. So there's not a recognition from a judicial perspective when it comes to a person providing their testimony or the statements that they would provide to police. So we certainly see that the lack of accountability measures for training for the justice participants, not just police, because often that's where the focus of education goes to, is training the frontline officers, and certainly that's important, but I think anybody who has a hand in the judicial system, it's important to share it there as well.
Thank you. MP Kazan, you have the floor for 6 minutes.
Thank you so much. My first question is for you, Ben. You spoke about NOL and how you support the putting in place an ombudsperson. Call for Justice 1.7 also calls for to put in place an ombudsperson. I know that the federal government had a feasibility study done. It's going nowhere. Why is it important, and very quickly, because I have a bunch of questions, but why is it important to put that in place right away, if you agree with me, and I think you will?
Oh, I sure do. Yeah, the power of negotiation to get things done and break through policies that we know are add red tape and things, we can negotiate as an ombud to try and humanize responses from government institutions and to advocate for a fair outcome. And I think that it makes a big difference. If we look at the complaints we've resolved, I think there's a lot of need in a lot of areas.
Okay, thank you. The second thing I want to bring up is violence within the justice system. We often look to the justice system to solve violence, but particularly with Indigenous people, the justice system perpetrates violence. And I want to read this very quickly. It's about Canoe James, who was incarcerated. I'm just going to read, some of it comes from her family. The family of Canoe James hopes the inquest into her death will take into account everything about her treatment during the nearly 15 years she spent in Canada's correctional institutions. James died of an apparent heart attack in 2013 while in the custody of the Regional Psychiatric Centre in Saskatoon. An inquest into her death began on Monday. But the inquest, and then it talks about what happened before. So I'm going to read this part. Before that January day, she suffered from several ailments, including obesity, type 2 diabetes, and high cholesterol. Her brother Cecil James and those not pre-existing conditions when she was sentenced for manslaughter nearly 15 years ago. Cecil also said her sister's treatment inside the prison, specifically the time she spent in a specialized confinement away from prisoners, needs to be taken into account. In 2013, Canoe's family said she complained of chest pains in the days leading up to her death. Inmates in neighboring cells also alleged staff ignored her calls. An investigation into death already found a nurse took too long to call a code blue after finding her unresponsive in a cell. Canoe was nearing the end of a 15-year sentence for manslaughter when she was transferred to Saskatoon. The 35-year-old had been transferred from the Grand Valley Institution for Women in Ontario after speaking out against the guards who she said were smuggling in goods in exchange for sexual favors, because we're talking about sexual violence. And I share that because I'm concerned about this kind of these misrepresentation of the luxury of prisons when we know there's a lot of sexual violence that occurs in prisons, particularly concerning for me because a lot of women end up there as a result of indirectly relating to violence they're experiencing in intimate partner relationships that make them make choices to avoid violence that have them end up being incarcerated. I know that the Elizabeth Fry Society did a report. In Manitoba right now, 85% of incarcerated persons are Indigenous. Women who have, had a life of gender-based violence are now incarcerated in places where systems are perpetrating gender-based violence. What's being done about that? I just feel like we don't talk about that.
Today, one of my investigators is in a federal prison for women, speaking with women about their experiences of sexual violence and pathways of criminalization. And so part of our investigation is looking at how survivors of sexual violence are criminalized in different contexts that it emerges from. And I'll just say, on prison conditions, many people have a relationship with the person who's been incarcerated. There's families that have that context, and if somebody's mistreated in prison, it distracts from the ability to heal. So safe human rights in prisons are important, and I think that's part of our stance too.
Because I agree. I know you spoke about prevention. And you spoke about the charter, the right to dignity and security of the person. One of the reasons I tried to pass a bill in support of a guaranteed livable basic income, because my argument is that the willful placing people in poverty is a violation of their dignity and security of the person. It was also in response to Call for Justice 4.5 of the National Inquiry. Do you think putting in place a guaranteed livable basic income is an important step to dealing with gender-based violence?
I think it aligns with an entire science of prevention, and I appeared in the Senate committee to support that bill coming through the Senate. Oh,
super. I didn't know that. This wasn't planned. And then just I want to move over to Madame Griever. You spoke about prevention as well. The Women's Shelters Canada came out with a report about how women's shelters cannot keep up with the need because there's not enough affordable housing with rent geared to income for women to go to. Why is it critical that there's greater investment? We talk about investment in affordable housing. This housing is not affordable, but in affordable housing with rent geared to income if we're going to deal with gender-based violence head on.
Leah, at this point, would you like to use your 2 minutes that you're going to get at the end right now?
Can I do that?
Let's do it.
Okay.
Yeah.
Can I do that? Sorry.
Yeah.
I'm a time hog.
Yeah.
Okay. Time's ticking. Okay, please answer.
Okay, yes, we believe there's a direct correlation between safe, accessible housing and prevention of femicide. Because as you all probably know, all of our shelter systems are overrun. We are a 40-bed shelter, but on a daily basis, we do have numbers 45 to 50 in shelter and across Hamilton. In the last few years, just at Innismuch alone, we've turned away over 5,000 women in requests for spaces, and that is just one shelter. Times that by how many across the country. So I know when I started 30 years ago in this work, women had 6 weeks that they had to come into shelter and then be able to find safe, affordable housing. Many times they were able to do it. Now we're seeing stays of 8 months, a year in shelter because they are not able to access safe, affordable housing, which then creates a backlog of women who need to come into shelter for safety reasons that are not able to access safe shelter because we have women who normally in the past would have then transitioned out into safe, affordable housing, staying in shelter for longer.
And would you say that a lack of adequate funding into prevention, we talk about intervention, but by that time, individuals are either murdered, disappeared, or experience violence. Do you think that a lack of investment in prevention is resulting in an increase in gender-based violence?
Absolutely. I wouldn't just say a lack of investment in prevention. There is no investment in prevention. And so I think that is essential because there will be a reduction in cases, costs, and femicides.
Yeah. Just with all due respect, by the time the police get involved, the violence has occurred. Would you, and I know that we have differing opinions about this around the table, but would you also agree that more focus, Ben, needs to be on the prevention if we're going to actually deal with gender-based violence?
We have to do both, prevent and treat survivors respectfully and listen to their safety concerns.
Yeah, and hopefully there's less survivors because we're preventing it.
Yeah.
Thank you.
Excellent, thank you. So at this point, we're going to start quickly our second round. I'm going to shorten it, and now we have just 3. We'll start with Dominique. You have the floor for 3 minutes.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam Chair. I'll try to be as quick as possible. First of all, there's a Jordan issue, which caused delays with unfortunate results for victims. There's C5, which has eliminated minimum mandatory sentences, and C, 75, which deals with domestic violence. Now, these 2 bills, do you think that these are, in fact, dangerous for victims?
On punishment specifically, that's outside of our mandate, the decisions. However, we advocated very strongly around C5 that if there was going to be a greater reliance on house measures or home-based measures, that there should be an increase in the safety measures for survivors, and that there needed to be structural reform to listen to what survivors might need if the person isn't incarcerated and is in their community.
Vous répondez quoi à des politiciens comme le ministre?
And what would you answer to politicians like the Department of Justice in Quebec that these errors should be corrected?
Comment on, but I will say in any jurisdiction that survivor safety matters and that we need to strengthen the protections and make sure that the justice system doesn't treat the safety needs of survivors as secondary.
Mais les lois sont importantes, là. C'est ce que...
But I mean, laws are important when the police have to apply the law. And this has repercussions on the victims. We've heard witnesses. Ms. Harris, what do you think? Don't you think these 2 laws should be revised and corrected?
Certainly, I mean, one of the things I advocated for was stricter bail conditions, and it's my understanding that the province is responsible for, the enforcement of conditions when it comes to bail. However, there's a lack of resources, there's a lack of funding availability. Ankle bracelets are only used once the offender has been pled guilty. So those types of conditions create an environment that allows for the offender to be free and the victim to be at risk of further abuse.
Madame Harris,
Once again, Ms. Harris, Senator Boisvenu lost her daughter, who was assassinated. And the Canadian Charter of Rights of Victims is toothless. I believe it was Senator Boisvenu that the police forces, the forces of law and order, are in fact shackled when they see these people getting out of jail, or not even go to jail because their rights are not being protected. Would you think that that is true?
As I had brought up initially during my first discussion, I didn't go into that great detail for the simple fact that it is still before the courts. However, that was a mother of 5 children who her offender, her abuser, was released for 42 days. She stayed at a woman's shelter. She had 5 children with her, the oldest being a male, almost 14 years old. She had to move out. It was no longer an environment that was for him because of the effects of the intimate partner violence that he had witnessed. There was no affordable housing available. They moved back to their same residence. She knew she was going to be killed walking her kids to school, and that is when she was kidnapped. So,
Merci. Thank you. MP Demoff, you have the floor for 3 minutes.
Thank you. Thank you to all of our witnesses for being here today. Ben, I have a few questions for you. One of them, I only have 3 minutes, a quick answer. You have done such incredible work, you and your office, with a minimal budget. Could you do more good work like the systemic review on sexual assaults if you had more funding?
We could do a lot more. An example would be with our systemic investigation. We had a contract lined up for somebody to conduct a focus group with people with profound disabilities to better understand the barriers of access to justice. Only $10,000, but we have no money to be able to afford it. So we could certainly do more.
Well, it's one of the recommendations I'd like to see in this report from this study is to increase the funding in your office. I first met you around Section 278.1, and I know you're supportive of changing that, as am I. We've talked about Jordan a lot. We've talked about a provision, my colleague read a provision from C-75. These are all Supreme Court decisions. And you mentioned you don't support the notwithstanding clause. On Jordan, the government actually did try taking it back, and the Supreme Court kind of said, away you go. So if we're not going to use the notwithstanding clause, are you saying the government should go back to the Supreme Court with an emphasis on Section 7? I'm just wondering how you think we can deal with these Supreme Court decisions that are really making it difficult, and more than difficult. Women are losing lives because of Jordan in particular.
Well, I'm certainly not a constitutional lawyer. I think that we need to lay a better foundation in law for the Canadian Victims' Bill of Rights has no cause of appeal, so it doesn't even come into federal court cases. Those rights don't play a role in a lot of ways. If we strengthen that legislation, strengthen our understanding and foundations of the Charter Rights to Life, then I think that it actually gives the Supreme Court more content to work with that can better account for survivor safety.
One of the things that has come up a lot in this study is bail. So in the province of Ontario, 80% of people right now are actually being held without bail. So these are technically innocent people, right? They're being held. But 20% are the ones that we read about all the time. We hear a lot about C-75. In my community, we don't have a courthouse that's functioning properly, so judges won't sit there. Is C-75 solely responsible for these issues with bail, or is there responsibility from the provincial governments to step up as well?
Well, it's probably a bigger answer than I could give in this amount of time. I think it's a shared responsibility. There's a lot of reasons that people are criminalized and brought in, people who are homeless that are held on bail because they don't have resources to support their release. but there's also conditions that aren't respected and no recourse, and certainly conditions that we see where there are very dangerous outcomes. So the government's done work, but it's an ongoing issue that needs further consideration.
Thank you.
Thank you. Thank you. Adrienne, vous avez la parole pour 2 minutes.
2.5 minutes. Thank you, Madam Chair, once again, and thank you to our witnesses for their testimony today. I'd like to ask my question of Ms. Gruber. In your opening remarks, you spoke of shelters and lack of space for abused women, victims of violence. I was listening quite attentively to the shortage of housing so that we could extract these women from the cycle of violence. Now, I'll give you an example. If a woman does not have any opportunity to find some affordable and accessible housing, she's trying to get back on her feet and everything else. So a domestic budget, the biggest cost, of course, is your housing. Now, women who are in an emergency shelter, they are obliged to stay there because they can't get to a transition house, for example. Somebody who needs to be housed on an emergency basis, they do not find any place to go to. We have to invest more in shelters, of course, but I think we all should invest in community housing. Give your thoughts on that, please.
Unfortunately, you have exhausted your time, Adrienne. Je suis désolée. 2 minutes seulement. The other, yeah. Je suis désolée. For those witnesses that didn't have an opportunity to answer any questions throughout the course of the meeting, any written responses are encouraged if you would like. At this point, on behalf of the committee, thank you for joining us today and your testimony. That will now conclude our meeting. Seeing no questions, meeting adjourned.